Commissioners are present today are Commissioner Halper, Commissioner Margulies, and myself, Commissioner Donovan. The way things are going to work today, for every matter that's on the agenda, the staff is going to speak first. After that, and there may be the commission may have questions for the staff. After that, the appellant will get 5 minutes after stating their name and address for the record. Everybody who steps up to the podium, that's what we'll need you to do. The opposition is going to get 5 minutes. Then we'll hear for other speakers for or against the appeal, and each one of them will get 2 minutes. After that, we will allow the opposition a rebuttal time of 3 minutes, and then the appellant gets the last bite of the apple, 3 minutes again. When that's done, we'll hear from the council office representative if they choose to speak, and then we'll close the public hearing. And we may still ask questions of staff, but the commissioners will then hold the discussion and vote. The presentations are all timed, so when I say 5 minutes, or 2 minutes, you're going to hear the bell go off over there, and I'm not going to interrupt you in mid-sentence, but I'm going to ask you to wrap it up right away. And if you don't end right away, I'd have to interrupt you, and I'd really rather not do that. The commission, but don't run away from the podium. The commission may wish to ask questions, but again, if you start going off on other matters other than responding to the question, then I might have to interrupt you again. If there is any, if you just want to make a public comment not related to any matter on the agenda, you can make public comment at the end of the meeting, and you can fill that out on the cards over there. Okay, so now we're going to start with our agenda. And the first thing that we have are always fun and entertaining departmental report.
Thank you. So I'm Pastusha, Senior City Planner for the City Planning Department. Just a quick update. The departments, we are finally expanding our staffing. We just completed interviews to hire additional 20 to 40 more planning assistants to the department. This has been a long time coming because we've been understaffed for quite some time. So hopefully in the next 6 to 9 months we'll have them on board. The city process is a little slow, but we're getting closer. We'll also be hiring in the near future, going through interviews and hiring for both the zoning administrators, which we're completely short-staffed on, and also for senior city planners. So the department's going through a little bit of growth to fill up its vacancies that we've had on for quite some time. The other thing is just to let you know, looking at filings, I just thought I'd probably give you, we look at, not for you, but in general for West LA, Harbor, and South LA, the filings have gone up basically about 20% in February. So we're still going through increased filings. The economy's doing good, so we're getting a lot more applications. So there'll be a lot more coming our way. Hopefully not here, but coming through the planning department. And those are the two big updates I have for you at the moment.
Thank you very much. Appreciate it. Okay, advanced calendar. We have it in front of us right now. Anything we should know about?
Not at this time, although Commissioner Waltz-Morocco probably will not be attending on April 15th.
I understand Mr. Waltz-Morocco's father passed away, and we're very sorry to hear that. And I know that you've extended condolences from you, but I would extend it also from the entire commission. Okay, and then we go to the next item agenda, 2B, commission requests. Do we have any? Okay, then we go to item C, approval of minutes from March 4, 2015.
I'd like to make a motion to approve the minutes from March 4th.
I second the motion.
Commissioner Margulies?
Aye.
Commissioner Halper?
Aye.
And Commissioner Donovan?
Aye.
And the motion is carried.
Okay, now we're going to go to the next item on our agenda, and actually there's two items, 3 and 4, both concerning the same address, and unless anybody tells me we can't do it, I just assume hear them both at the same time, hear the testimony regarding it, and make decisions regarding both. So the first one is number 3. It's ZA 2012-1770 CDP CUB 1A with a related case DIR 2010-2932-SPP-1A, sequel number ENV 2013-2592-MND, and the address is 259 South Hampton. This is an appeal of the zoning administrator's decision to approve a coastal development permit. The other one, item 4, is DIR 2010-2932-SPP-1A. Related case is EA 2012-1770 CDP CUB-1A. Sequel number ENV-2013-2592 MND. This is again regarding 259 South Hampton Drive, and this is a specific plan project permit compliance review. Before we get into both of these matters, I do want to make a statement. I have been sent several emails regarding this particular case, and I cannot emphasize more strongly than this. You cannot send me communications separately. That's an ex-parte communication. It's not allowed. Any communications to anybody on this commission must go to the commission assistant and not directly to us. I try not to be rude if someone were to call me up, but I really don't want to talk, because if I do, I have to disclose every word that's said, and it will not, I repeat, it will not help your case to make these ex-parte contacts. I received these emails, and fortunately they had the address on them. I did not review them. I don't even know who they came from. And it's just improper. I know you want to get your point of view across. You send it to the commission assistant, and she will then forward them all to us by email if need be, if there's not enough time. So you will get your point of view across to us if you do it that way. If you send it to me directly, you will not get your point of view across to me, because I'm not going to read it before the hearing. The other thing I want to say is that it looks like we're getting stacks of stuff on cases here. And when we have this meeting, I can't not listen to people who are testifying, because I have to read something that's sent at the last minute. Again, if you send it to us even a day before the commission hearing, we will make every effort to read it. But when everybody's here and waiting to have their matter heard and wanting to testify, I can't be just reading something else that just came in. I know that everybody's under time constraints and all that, but really, just get it in the day before and send it again to the commission assistant. She will send to us, and this is a very diligent commission. We will read everything that we get, but it's got to come through the proper channels, and you got to give us a little more time rather than the very day at the hearing. So that's my lecture for today, and I think right now the best thing to do is to move on and let staff tell us about these matters.
Good afternoon, Commissioners. My name is Kevin Jones. I'm the city planner that works in the plan implementation section for West Coastal, and I was the person that prepared the recommendation on the appeal that was considered back in January, and I also prepared the reconsideration report. What is before you is really, since the applicant came to a meeting of the Area Planning Commission within the time allotted, the applicant asked for a reconsideration of the appeal. So the way that my report reads is that the previous staff report is still being presented, or being represented to you before, and that was done on January 7th, is being presented to you also, because all of the information that was contained in that report is still before you today. In addition, there's my reconsideration report that contains information about the revisions or added information that was provided to the planning department and is before you for you to consider the entire appeal together. Included in that,
Excuse me, one second. Okay. I'm sorry. I said this. Please go ahead.
included since January 7th are revised plans that are dated March 16th, but dated with the planning department staff of March 18th. These are to supersede the previous plans that were in your January 7th packet. In addition, there is information on a traffic analysis that was added and a noise analysis that was and is presented to you. But I probably should first explain to you what the project is. This is the project or the proposed project is the change of use of a building that contains 1,042 square feet of retail store area and 616 square feet of fast food takeout only restaurant area, and changing it to a 1,658 square foot full service restaurant. The project includes the use of rooftop dining and a total approved restaurant service floor area upstairs and downstairs not to exceed 1,000 square feet in area. Mind you, the service floor area is an element or a provision that's described in the Venice specific plan that is used for the calculation of parking. So in Venice, in the specific plan area, they count only service floor areas. They do not count the back of house like kitchens or bathrooms or ADA required path of travel. So it's the service floor area that is related to the parking impacts. So that's why it's clearly delineated and described in Venice restaurants as being service floor area. The project presented is required to meet as presented is required to meet the findings required in 8C of the specific plan relative to the compatibility of the project with existing neighborhood scale character, and the project is not detrimental to the surrounding neighborhood. The planning department, after reviewing the plans and reviewing the guidelines that are contained in the specific plan, the project complies with what was analyzed in the first project in the project description of the director's determination, allowing a service floor area of up to 1,000 square feet. It allows a height up to 30 feet. Let me see here. Sorry about that. Yes, it says that it shall be a height not to exceed 30 feet. It needs to be below that amount. It allows for the full restaurant and sit-down service there. It allows for parking that is delineated here. Now, parking probably is the driving force for a lot of issues in the Venice specific plan area. However, the Venice specific plan contains parking standards and guidelines for the amount of parking. However, as it states in the very beginning of the specific plan, whenever the specific plan is silent, any issue then defaults to what is contained in the Los Angeles Municipal Code. In this case, and in many cases of Venice, you have non-conforming parking rights. And that is intended to address the fact that many buildings throughout the city, and particularly in Venice, that are older, that fully occupy the entire site, are entitled to certain credits for parking. If a building fully occupies a space, there are credits that are available to them. In this case, in many cases, and has been all the case before this commission and before the director, are that you measure the amount of floor area of the existing space using the standards in the Venice specific plan for the existing use. You then do a calculation to what the new use would be. So it's as if those parking spaces exist. However, that is clearly the intent, because there is no way that a structure can, or a property owner can provide parking when they are not tearing down the structure altogether. So that's why they're non-conforming parking rights. So in this case, the project has a credit of 7 parking spaces, and that the balance of 14 parking spaces can be provided in any one of 3 manners that are clearly delineated in the specific plan. In this case, as demonstrated by the attachments, the owner decided to pay the designated $18,000 per space that's delineated in the ordinance, which equals approximately $252,000 that were paid into the parking fee. And with that, finding what the director of planning has found with the revised plans that meet the height, the service floor area, and the parking amounts and the parking payment fees, is that the project meets the provisions of the specific plan, and the project permit compliance should be approved. With that, I'll step to the side and allow Mr. Irving to provide his explanation of the zoning administrator's actions on the coastal development permit and the conditional use permit to allow the service of alcoholic beverages.
Good afternoon, Commissioners. My name is Theodore Irving. I'm with the Office of Zoning Administration. And so we're here to discuss the appeal of the ZA actions. And those actions are the coastal development permit, and the other action is the conditional use for alcohol sales. And so the appeal was filed by Ms. Elena Morrissey, and that's the only appeal that we have to record. As you have on record, there are findings that have to be provided for compliance with the Coastal Development Commission, and those findings were made by the zoning administrator. The same could be said for the conditional use application request, I should say, and those findings were made. During our January appeal hearing, we did receive a letter from LAPD who was opposed to the project. And that letter was dated December, I think it was December 19th, but that letter came in after the decision had already been issued, but before we had the appeal of the hearing that took place here. But nothing has changed with regards to those two actions. We had talked about the revised plans that's been submitted to the application, but nothing has changed from the zoning administrator's position with regard to those actions. They still stand behind the findings that were made for the coastal development permit, and still stand behind the findings that were made for the alcohol permit, the CUB permit. So that concludes my remarks.
Commissioner Donovan, so on January 7, 2015, we granted the appeal regarding both aspects of this project, correct?
Yeah, that's my understanding. The appeal was granted, and subsequently.
So what I need to know is what has changed since January 7 that will cause us to reverse our position. So in other words, has the project changed, or what new facts have been elicited, or that we should be?
Yeah, there has been some change. I'll let Kevin talk to that. There's some considerable changes that were made with regards to the proposed structure.
Well, let me see if I can be more specific. As I recall from the January 7th hearing, the major issues were noise, parking, and traffic. So given those particular issues, what has the project changed in any respect?
Commissioner, this is Kevin Jones once again. One of the other issues, as brought up by many people, is that the plans that were in the project permit compliance were for another design, and that they were not consistent with the information that was contained in the zoning administrator's file. That issue, which I think was a driving point for many people, has been resolved because now we have the exact same plans that are dated March 18th and are the same for the consideration here at between the project permit compliance and the actions by the zoning administrator's office. So now you have exact same plans. To address the traffic issues, you will notice that the traffic report that was prepared indicates that there is less than a significant impact from this use. In addition, a noise analysis was prepared that talks about there could be, once again, that there are some impacts on an increase of 3 decibels, but it also makes recommendations on how to mitigate those impacts even further, including walls. You could also request that the entire rooftop area be enclosed. But once again, the project permit compliance allows for up to 1,000 square feet of service floor area, both on the second floor or rooftop, and on the ground floor at this point. So, given the information that was received between January 7th and today, that is the information that is contained. I should point out that today, within the past 20 minutes, we have information prepared by a different acoustic professional that has some questions about the noise study that the planning department has not had the opportunity to review this information dated March 26th or March 23rd. It was not sent to us. Apparently it was sent to the commissioners directly for them to consider. However, what was analyzed and considered in the staff report for the reconsideration is that we found that information to be adequate for you to consider or to make revisions to the environmental impact conditions in there regarding noise based upon that added information that was not available to you back on January 7th.
And maybe I can be even more specific on my inquiry here. Even though the design of the building is different than perhaps what was presented to us, it still maintains a rooftop deck, correct? And the deck is not covered. It's got walls on the side. And that was what we looked at in January too. They still had a rooftop deck, it had walls on the side. Am my memory correct on that?
But you were making an absence of not having a noise study. So that's the difference, is that you now have information from one acoustic professional that is now being presented to you that presents more information for you to consider.
And the acoustic professional that submitted that, was that on behalf of the appellant or on behalf of the applicant? Because I saw a couple of them.
Steve Rogers was hired by the applicant to perform these studies, and that's attached to my staff report. It's Exhibit A-G. It's dated March 11th.
Commissioner
And then I see
Halper.
another report here from Noel Gould.
Commissioner Halper, on that particular issue, you're correct that came from the applicant. However, at the same time, during that last meeting, we did get input from two people who represented themselves with expertise in this field, and they were both supported the appellant's position. And now I see in front of me, I just had a chance to read it quickly, an additional study by a professional, again supporting the appellant's position on the noise, excuse me. Weighing it, not in numbers, but the fact there is a difference of opinion given to us by professionals on the noise. So nothing has really changed. It's pretty much where it was when we made our last decision. And I made my decision based on pragmatics. The outside, there's nothing that dealt with the outside noise that in a restaurant area, or people leaving and coming, that would nothing to mitigate that noise in a residential situation by either of these studies. But pragmatically, if you're serving liquor, if that's one of the requests, I would imagine that would also add to the noise factor. So I don't see any real shift in the noise issue.
Theodore Irving, planning staff. I think each of the commissioners should have a revised plan that was submitted by the applicants. It's dated March 18th, Exhibit A. If I could direct it.
I've got a plan here, Exhibit D. You said there's.
Well, I'd like to direct it to it. I thought the commission staff had distributed, but there is a revised plan as I submitted. As Kevin pointed out, one of the discrepancies, or one of the issues that was raised at January 7th was that the director determination report and the ZA report had two sets of plans. We rectified that. We got inside each of those files the proper plans that should have been presented or should have been issued when the determinations were initially issued. Subsequently, the applicant has provided another set of plans. And that is the plans I'm asking you to look at right now, and that's Exhibit A. It's stamp dated March 18th, 2015, and I think it's Exhibit D in your report. So if you look at that plan, it's a little bit different from what was approved by the zone administrator and initially, essentially what was approved by the director in the director
Commissioner
determination.
Hopper, again, if I could, Mr. Irwin particularly. I want to just address the fact that there is a request for an alcohol license here, and there be outside the premise comings and goings and whatever else in a residential situation. How would you justify that?
Okay, well, I just want to make certain that we talk about the changes and that we considered all the changes, because if you see the plans, there has been an attempt to enclose the building. Initially, there was a rooftop patio proposal. In the March 18th revision, they have enclosed that building. So that addressed some of the noise issues that were raised. Now, with regard to the people walking around, that matter, we don't have any proposals from the applicant or how that's going to be addressed. Folks leaving a restaurant will walk from a restaurant, walk to their car, walk to transit, but people will walk after having been served alcohol. But in terms of the noise that people discussed related to the patio, the revised plan attempts to address that.
Okay, Commissioner Donovan, I realize that there were technical defects in the application because of the different plans that were submitted to you. But as I recall, as we went through the hearing, it boiled down. We still had an issue of the noise from the patio, and I believe that they were saying we weren't going to put a roof. They weren't going to put a roof on it, but they were going to put walls around it. And these new plans simply restate that they're putting walls around it. There's still no roof on it.
It would, this is Simon Pastor, I think it'd be helpful if you would get the applicant team up to explain their plans.
Totally, yes.
Well,
for the detail, but
we're going to do that. I just wanted to understand from staff's point of view, because I just want to know what is new.
yeah.
We had, from what I remember, we had an enclosed patio on the roof last time. Now, you've got new plans that stay there, but we had an enclosed patio that time. We had traffic was an issue there. We now have a report that says there's going to be 279 trips. So now we know exactly how many cars are going to come in here. But we knew that traffic was the issue at the time. And we also knew at last time that the parking was an issue for the appellant and for the neighborhood. And so we based our ruling on all of that. So the substantive portions of these issues are unchanged as they are before us right now. Is that correct?
Well, remember, commissioners, when traffic was an issue, remember you did it in absence of a traffic study. While there is an increase, please notice that the report concludes that there is less than a significant impact that would be in keeping with this area. Also, keep in mind that this property is zoned M1 that would allow this use on it. While it is important to note that adjacent next door is a residential uses, this is what is the department's recommendation regarding a restaurant use at this location. Mm-hmm. So while it is an increase in traffic, you're right, but remember the traffic study concludes that there is a less than significant impact. So I'm hoping that provides you the guidance that you are allowed so that you can consider other things.
I understand that's what the expert said. The expert said 279 trips, and the expert said that's less significant. I have a feeling I'm going to hear that other people disagree with whether or not it's significant or not. And that really was the issue all along, what the exact amount is or what an expert says. Having heard dueling experts many times, to put the label on calling something less than significant doesn't make it necessarily so. The 279 trips, that at least has something that I can lock onto. Now we'll and then this commission then decides whether or not we think that's significant or not. Am I right in my reasoning there?
Yes.
Okay.
Yes, your prerogative to decide
Okay.
on that. But
All
if
right.
I could just,
But you are limited by the city's standard thresholds. I mean, you have that consideration, but you also have to be consistent in your standards based on the city's thresholds. Now, this is a reconsideration that you granted the applicant in order to submit additional information. And so I think I'm just reminding you that you need to go there and get that
We're going to
information
listen to it
first.
all, for sure.
Okay.
Yeah, okay.
Commissioner Hopper, once again, if I may, when we talk about the parking, I do, and I appreciate the, Mr. Jones here, the care that you gave in explaining it, because I didn't understand it before, and now I do understand how you came to the conclusion that you did, that the parking requirement was met. However, this is in a coastal zone. It's the Coastal Act requires that the parking provide, this is a zero parking or virtual parking of 21 slots, but it's not real parking. Does not in any way alleviate the demand for again on the site. My question is, how do you justify this in the Coastal Act, which requires that you provide, you don't impact beach parking? Could you help me with that?
yeah, so the coastal development permit is implemented for the most part by the specific plan. We use a specific plan as an implementation tool to implement the Coastal Development Act. That's the implementation tool. You have the act, you have to implement the act, you have to get someone to comply with that.
Okay,
So with that said,
let me just ask you on that one. The Venice coastal program, that's not a program, but the Venice coastal, whatever the title is, requires that you have, because of the floor space of 996 square feet or whatever, it requires you to have 20 parking spaces. Now but now you're telling me these are virtual parking spaces, which I understand how you reach that conclusion. However, the Coastal Act doesn't deal with virtual. I believe it deals with dealing with non-impacting beach parking. So that's where my question is.
Kevin Jones, once again, from the LA City Planning Department. When you review both the specific plan and the coastal land use plan that is the policy document that came out of, or that the specific plan came out of, remember, all those guidelines and those standards were taken from that Coastal Commission approved document and implemented here. It was well disclosed to the Coastal Commission that non-conforming parking should be available to older structures that are not there. And while I do understand your concern about that, what the Commission was also concerned about is the property rights of a building that is not being changed, that consumes the entire site, which is why, and it is an older plan, I'll grant you that, yes, the specific plan needs some amendment. But at the time it was written, and what we're operating under are the parking standards and the fact that the Coastal Commission chose not to limit the use of non-conforming parking rights by excluding it and not speaking to it in the policy document that the specific plan carried forward.
You're approving an increase in the intensity of the activity in that area. You're doing that mindfully. And knowing that there's a parking issue, the department has determined that it's okay to increase the intensity in that area, knowing there's it's only virtual parking. It's meeting virtual standards, not a reality in the field. Do you consider actual field conditions when you make these determinations?
Yes, we do, but remember, the problem is that many homeowners and businesses just do not have parking available to them. Either some houses have one garage parking, or no garage parking, or none on the site at all. This is the very same issue, which is why the Coastal Commission chose not to, in the policy document, to limit the use of non-conforming parking rights. Is to acknowledge the fact that Venice actually was a territory unto itself, and structures started being built before then, even before the city of Los Angeles had parking standards. That's the reason why 1228 was created, to allow for the consideration of non-conforming parking rights. So by its absence in the policy document and its absence in the specific plan, it was intended to allow for property owners that do not have the ability to tear open their buildings to put in a parking space, to allow for decision makers to move forward within reason on the amount of development and the amount of parking that we can require.
Thank you.
Commissioner Margulies, I'd like to go back to the CUB for a moment, and I'd like to ask about the letter that was submitted on December 29, 2014 from Charlie Beck, the Chief of Police, that recommended, it says that granting the CUB could adversely impact the surrounding communities. And that's because of the number of on and off-site licenses that are already in the census tract. Understanding that there's mitigation proposed with the project has proposed mitigation. Assuming, well, I guess now I have a little problem here but I don't think anything substantially has changed other than the number of seats. And that doesn't substantially change the issues related to the liquor license. So we have a letter here from the police that basically says that they don't recommend the liquor license here, or that it could, because of the high concentration of alcohol beverage control establishments, this could have an adverse effect. If I assume that well, how does the planning department come up with mitigation without reviewing that with the police department, so that we get a sense that that your mitigation methods and mechanisms are acceptable to the police and agree with what they think will adequately mitigate this higher concentration of liquor establishments in the area?
In most cases, the police department is apprised of CUB applications. They respond with a set of recommendations for consideration to be included in the decision letter. In this situation, that did not occur. If the decision letter predates this December 9th letter, and so we don't have police department conditions. We were not aware of police department thought process on this. So this decision was issued without input from LAPD.
What was the date of our last hearing on this case?
Well, we're talking about, if you're talking about the January 7th meeting, that was about the appeal of the zoning administrator's action. This letter that you're reading came in after the zoning administrator's
Right.
action.
But in terms of-
So if it's something you would like to consider now as part of your deliberation, you're welcome to do that.
Okay, well,
It was not available to the
two
zoning
things I'd like to
administrator.
point out. One is, this issue was raised, I remember, by Commissioner Walter Morocco at the time of the appeal hearing.
Okay.
And we asked these questions, and I believe it had a strong flavor on the outcome of our decisions. The other thing I'd like to point out is that in this item 4 reconsideration package that we have, there's a printout here from the California ABC license query system, and it has an incorrect census tract. This is, when I looked at ZEMA's census tract for this area for 90210 is 2734.02. It struck me that something was wrong here when I looked at the business names and the locations of the establishments in this report, because they're all in, they seem to be sort of downtown and east. So there's a.
So you're pointing to a ABC printout, and it's a separate printout?
It's a list that follows the, it doesn't have an exhibit number, but it's about the third or fourth page in from the plot plans and or other maps. And at least in my package, it's not the right census tract, and therefore none of these businesses are in the Venice area. And where this is 2 pages, I think that the Venice one is probably about 5 pages.
Could you repeat that census tract number again?
When I lived on ZMIS, I got 2734.02 for the Venice zip code.
Right. And then you have a separate document that references a different.
It occurred to me when I looked at this list of retail licenses, there was something strange about all of them being on West Temple, Silver Lake Boulevard, Los Angeles, more at West Temple, more Silver Lake. So I just want to point out this is not the correct list of license holders.
If I could direct you to page 19 of the decision letter.
Right, I know there's a summary there that talks about 12 on-site and 3 off-site licenses.
And it correctly states the census tract number, which is
Correct.
Okay.
Yes, we match.
Okay.
We're in agreement on that. Thanks. I didn't have to look at ZMIS, I guess. It was right there. But this paragraph clearly gives us a picture of the 2 on-sale and 2 off-sale licenses that are allocated to this census tract,
Right.
which also seems a little strange given the character of Venice. But the fact that there are so many more.
I think we would agree that a census tract is a count of households in the community. And so we know that this community is, for the most part, zoned and designated for light manufacturing uses. So you're not going to have a lot of households in a zone.
Please.
You're not going to have this is ABC records. ABC is extracting this information based on census. This is their information. So they extract this information based on this area. This area, okay, as we know, is designated for light manufacturing and a zone for manufacturing.
So would you say, I guess that just makes me wonder when, I'm hoping that when the Los Angeles Police Department evaluates the situation, they're not making a determination based on the zoning.
No.
They're really looking at, I know, and that information is included about the number of crimes in this area, which is almost 3 times the city average.
Right.
And so that would have to be the basis of their recommendations.
And so if you look further on page 19, you will see that they have what is called a crime reporting district, which is completely different from the census tract. Now, what you can have from time to time, and I think in this situation, is that a census tract is divided by a street. One side of the street could be manufacturing, the other side of the street could be residential. I'd be candid with that. I don't know if that's the case here, but there oftentimes is a situation where one side of the street is completely low density land use, light manufacturing, zone for manufacturing, has very few population, and just across the street you could have high density residential. However, the census tract would capture a population that says, hey, there's not a lot of alcohol sales here because of the low density. Now, when the police does its reporting, it's going to capture not only the census tract where, and in this case, the subject site is, but it's going to capture the residential zone property across the street. And so it's going to capture all of that. So you will see a high number for crime because it's capturing more than one census tract area, whereas the census tract area that we're reporting is strictly for that zone of the property. We just report the facts.
Kevin Jones from LA City Planning. Commissioners, keep in mind that in my experience of doing community plan updates, there are multiple census tracts within a community plan area. And while I don't know what the boundaries are of this particular census tract, because those are established by the federal government, we tend to hold on to those because it allows us to track population growth, business trends, those type of things. To answer your question, I would say that Venice has multiple census tracts because The federal government bases it upon population size. So whereas in the valley, a census tract might be larger in actual area, it tries to capture about the same population size, to give you a little bit of background. In Venice or in near MacArthur Park, where densities are higher, the area of a census tract is going to be smaller to capture a set amount of, to capture a population trend. I'm hoping I'm giving you a little bit of clarity. I'm not saying that it has to deal with land use. It's set by the federal government. It has to deal with population size, but I don't know the boundaries of this particular census tract and how the police department based their decision on that.
Well, I'd have to say, as a Venice resident, I would hope that all of Venice isn't covered by 2 on-sale and 2 off-sale liquor establishments. I think we'd all be a little high and dry in Venice if that was the case. So what I really want to focus on is what you pointed out in terms of the crime reporting district number 1412, in which this area of the city had a total of 539 crimes reported in 2012, compared to the citywide average of 146 crimes, and a high crime reporting district average of 176 crimes for the same period. So clearly, in 2012, this area was above average, and we should be concerned about the amount of crime going on in this area.
Okay, we're going to start taking our public testimony on this. I do not have a speaker card for our appellant who goes first, so I'm assuming the appellant is here somewhere. The appellant? No. The appellant. This is an appeal. It's I told you the procedures are going to do. The appellant goes first. They get 5 minutes. Applicant then goes next. They get 5 minutes, and then we will hear testimony for and against the appeal. Each person gets 2 minutes. Then at the end, applicant gets the first say, a rebuttal for 3 minutes, and then appellant gets the last 3 minutes. That's how it's going to go. So first we have to hear from the appellant. And we're going through right now, just so you know, I've got a bunch of speaker cards for the appeal, and I wasn't sure which one was for the appellant. Okay. So we have our appellant first. Please state your name and address, and you have 5 minutes.
Good evening. Thank you for seeing us again. Ilana Morosi, 615 Sunset Avenue, Venice. Before we get into the meat of tonight, there are a couple of procedural issues that I actually want to address with the Commission. The first of which is that I don't believe due process was afforded in terms of the community being noticed about the agenda for tonight, whereas it's supposed to hit the internet 72 hours ahead of time, as well as be physically posted. It actually didn't hit the internet till 32 hours prior, which was yesterday morning. It should have been online 4:30 p.m. on Sunday, and it wasn't posted online until around 8:30 yesterday morning, Tuesday. So it appears that's a requirement that the city has imposed on itself, that they are going to electronically notify people via the internet, and seeing, that's a posting on which a lot of people rely, because we can't physically drive downtown from a different district 10 times a day to check the agenda. And as I said, it wasn't posted till 32 hours prior. So on that basis, we actually believe there was no timely compliance with the agenda posting requirements. For that reason, we actually asked that this matter not go ahead today, but be rescheduled so that everybody can have adequate actual notice of the compliance.
Okay, Commissioner Donovan, the notice requirements are subject to the Brown Act, and it's my understanding, well, first of all, the Brown Act way predates the internet, and I don't think it's been formally amended. We'll look to our city attorney for guidance on this, but I don't believe that there's any legislative requirement that requires a posting on the internet at this time. Not that it isn't a good idea. The second thing that I do understand is that the posting is in physical places, including, I believe, the site of the project. But I'm not clear about that either.
Nothing's
But
posted.
and also, I believe that notices would have been sent out to the appellant on a reconsideration as well. So you would have received notices, and then it would have been incumbent upon you to send out the emails then to notify everybody about the hearing. But let me listen. We'll get a response right from our city attorney.
The Brown Act does not require for this body to post on the internet. It would require for city council, as the city does have a website. So that requirement only applies to city councils, not to planning commissions. So there is no violation of the Brown Act for this meeting. As to how it's been noticed, I would defer to Commission Executive Assistant.
This is the Commission Executive Assistant. After getting an email, I triple-checked this. This notice was sent out to the 500-foot radius, published in the newspaper, more than a month ahead of the meeting, and well in the time constraints of 24 days prior. It was sent out to a 500-foot radius. More than 450 people were sent notice of this hearing.
Okay. So I think we're going to go ahead and hear this, and we'll start your 5 minutes right now that we've resolved the procedural aspect.
Okay. The next, actually procedural concern we have is that, might I just say that regarding that last issue on the agenda, it actually on the notices that are sent out, it actually says that the agendas are posted for public review in the lobby of City Hall East and are accessible through the Internet World Wide Web and there is a website. So that, I think the fact that this goes out on every single notice throughout LA sets some kind of precedent or some kind of obligation of the city to actually do that. Question?
Commissioner Hopper, I think, I don't know what how you'd solve the issue, but Monday was a official holiday and staff was not working, as far as I know.
Yeah, but for every Wednesday's meeting, it has to be noticed. The agenda has to be posted on Sunday evening.
Well, let me see if I can. You, as a appellant, you did receive notice, didn't you?
I received notice, but I was searching for the agenda for days just to see if
you
it was
received
still
notice
on.
that we were going to have this reconsideration hearing before 72 hours before this hearing.
Correct.
Okay.
But I'm not the only one that relies on this
I know.
mode of information. Thank you.
And you know, I'm not saying that it's not a good idea to have these posted on the internet. I will say though, it is incumbent on all citizens and residents of the city you're going to have to do some work on your own because the city's not going to do it for you. But I'm glad to see you here, and we're happy to hear your testimony today on your appeal. So why don't we get going on that?
Okay. So my next, it's actually also a procedural issue in that the late submissions of some of the exhibits, they actually submitted to the file as late. Well, they weren't necessarily stamped the date they were received, but the 18th of March was when the latest plans were submitted. We didn't get any notice. I didn't get notice of that as the appellant. I just happened to be downtown 6 days ago looking at the file and happened on them. So I think it's a due process issue in that, correct me if I'm wrong, in that the appellant and in fact the whole community who are concerned and affected are not privy to all the new submissions, and the fact that we are in the middle of an appeal period, I'm wondering how valid and how appropriate it actually is for brand new plans, reports, things that are really could possibly affect the the appeal to be submitted within the last week prior to the rehearing.
Commissioners, as the Commission Executive Assistant, I'm going to read from the second page of the hearing notice that went out more than 24 days ago that says testimony. Written testimony may be submitted prior to the hearing. Let me see it. Actually, let me find file review. It's on the second page, third paragraph. The complete file, including the determination, is available for public inspection in the Commission Office, Suite 272, 200 North Spring Street, Los Angeles, between the hours of 9 a.m. to 4 p.m. Monday through Friday. Period. It's always available. It's for anything that's been submitted.
Thank you. I think one of the issues, we're getting submissions both for the appellant side today, which the applicant probably hasn't had time to see either. That's the nature of what happens on these. Someone will get up and try to hand something even after you're done for us to look at. You know, it would be great if we could get all this stuff much earlier, but that's not the way it works.
I mean,
Excuse me, Kathy Phelan, City Attorney's Office. I would like to add that there was a claim that the site plan was not available, but it was in the staff report. And when the staff report is made available to you, it's made available to the public. That is a requirement of the Brown Act, and it's available at the Commission Office as described in the notice. So that site plan was available, and I don't believe there's a due process issue there.
To that, may I state that it was provided, that was provided within the 10 days, but we have a 10-day period of submission. By that time, the 10 days had expired. I didn't know, I was sent the packet 2 days ago. I received it, which is hardly time, and you guys, I think, are receiving it this evening, so.
No, we received the packet last week.
Okay, well, my concern is that we have two seemingly conflicting applications. We have different plans, different information has been submitted at different times. The entirety of the record is a hodgepodge. Written reports and plans, other data don't pertain to what was before the professionals prior, and as late as a week ago it has morphed into a brand new project, and you can see, and as the city stated, that it is quite a significant change in the plans. So now we have a situation where no one has had the opportunity to scrutinize, digest, integrate the essence of the new plans and all the new submissions that came in within the last week. So my query is that something that can happen in the final week during an appeal period? I suggest that in the interest of everybody being able to do their jobs and for a review in court, that this actually should be sent back with the new submissions to the ZA and the planner, so that there's a unified set of plans submitted to them and everyone knows what is what.
Well, I guess we can note your objections to the timing and all on this, but we're going to proceed today, so maybe it would be best to get to the substance of your appeal.
Thank you for noting that. So my concern is the plans and the change of use. Firstly, as we see that we have a third set of plans. So we have the confusion of the last hearing where we had two separate set of plans. The DIR was based on a single level. The DIR was based on a single level set of plans for 1,658 square foot. The ZA was based on, there we go, the DIR. The ZA was based on a two-story, which was 2,800 square foot, and now today we have a new set of plans, which is also 2,800 square foot, two-story, brand new iteration, as the city already have mentioned, and so now we have a problem of three sets of plans. Those plans, the new plans, have just been placed into the two files and apparently just supersede. I'm not sure if that's the way, if it hasn't been through the proper course of being vetted by city and by the community. So that's my concern is about the third set of plans. Next